Federal High Court Amendment Act 2013 and for related matters. Mr. President, recently this night restated his faith in our democracy by enacting the Electoral Act 2022 as a landmark legislation to reform our electoral legal framework. By this, Mr. President, we gave INEC more tools to organize free, fair, and credible elections as desired by our citizens. The reforms intended by the Act are already bearing good fruits that are increasing the faith and confidence of our people in our elections. Mr. President, as may be gleaned from sections 29 and 84 of the Electoral Act, the key element of the electoral reform is the reasonable and logical domiciliation of the commencement of virtually all judicial contestations relating to our federal elections within the exclusive jurisdiction of the Federal High Court. Necessarily, Mr. President, this has increased the work burden on the Federal High Court. By this, Mr. President, we also rightly left the High Courts of the states and the FCT to inquire exclusively into matters relating to local government/council elections conducted by the states and the FCT. Mr. President, naturally, the additional burden that now rests on the Federal High Court has huge ramifications for a speedy and judicious dispensation of justice without overstretching the justices of the court. It is our duty, therefore, to respond properly to this challenge by enacting a measure that increases the number of justices of the Federal High Court. This, Mr. President, is the essence of this bill. Distinguished colleagues, we may relate to this matter from different perspectives, but personally, as a major stakeholder in the judiciary and legal profession, and one who deeply appreciates the huge patriotism of our judges, I firmly believe that we should never delay in attending to whatever will make our bench perform better. It is to this end, Mr. President, that this bill simply and reasonably seeks to increase the number of judges on the bench of the Federal High Court from 100 to 172. This is to enable the court attend optimally to its already identified increased burden. Mr. President, I may ask, if I may say, all of the litigations that were shared between the various courts of the various states, FCT, and the Federal High Court, all of them now are domiciled only in the Federal High Court. And of course, we're actually having more litigations on a daily basis. In line with Order 76, Subsection 3 of the Senate Standing Orders 2022, a compendium of the background and financial implications of this bill, Appendix 1, is attached herewith for your consideration. Amongst others, the projected marginal annual salary cost burden on the federal government is about 44 million for the 72 new judges. This is no doubt a reasonable and responsible cost, distinguished colleagues. Mr. President, this night's Senate has consistently responded with patriotism to issues that are of fundamental essence to this great country. This is another moment, distinguished colleagues, I urge you to support this bill. Therefore, for the greater good of our republic, I hereby humbly move for the second reading of this bill. I so move, Mr. President.
Say that I see this bill as a consequential bill, meaning that, just like he said, we've taken some decisions, and necessarily we must back that decision with some very, timely legislation, and this bill seeks to do that. Mr. President, distinguished colleagues, the only area I would like to make some pointers to is, of course, we are raising it from 100 to 172. As much as I don't understand fully the reason for the number in particular, even though one may want to fathom out that it is to create equity for all the states to be fully represented in the appointment of these federal judges. If this is true, Mr. President, distinguished colleagues, I would rather want the committee, perhaps when you go for the next legislative action, to consider perhaps this number. Because as it is, if you say 172, if you divide it by 37, that is the 36 states plus the FCT, it will give you like 4.6. which means 4 people with 0.6. It means invariably some states will have the 4 while some may have more. If we want to go to the letter and spirit of the Constitution that says we should try to balance at all times, why not as a legislature just go ahead and say 5 at least per state? That way we'll be having 185, so that rather than taking it to the 172, of course they can take it to 185. That way we can guarantee subsequently some element of equity by all the states of the Federation to actually be fully represented by qualified people on that system. Mr. President, distinguished colleagues, this is a very timely bill. It's a very straightforward one. These are just my own layman's understanding, and I felt whatever it is, the Constitution that says we should carry every segment of this country in such a manner that everybody has a sense of belonging. I think if we look at it, it will be a very good and timely one.
Thank you. Before I call London, Lagos or Port Harcourt will be the same. No, you can't call Yobe now. I assume that some states or jurisdictions have more cases to deal with. So if we are talking about distributing the judges in equal number, are we talking about appointment? Or,
Appointment I'm looking at.
Oh, okay. It's okay. I was just thinking aloud.
Mr. President, the point I'm making is I'm not looking at if they are appointed, they are deployed on the basis of need. But what I'm saying is in terms of giving every state that equal stake to have their citizens participating in the federal, in terms of appointment, that is the one I'm talking about. So if you have that number in that way, it means when you come to appoint, after all, in most of the approvals we have been given, it is on the basis of that equity.
I understand now. Yes.
20 of those people.
Yeah. Okay.
Mr. President, I also stand to add my voice in support to this bill. We just listened to the incoming substantive CJN of this country. And even from the short analysis that he gave in response to the question by one of our colleagues, distinguished Senator Suzwan, it's obvious that there is a need for the National Assembly to support the judiciary in ensuring that they are able to take care of the volume of cases on the docket of our court. The Federal High Court is one court that unifies everybody. And when we are talking about the number, yes, we might agree on a number that can be shared evenly among the 36 states plus FCT, but I don't think the number needs to increase to 185. If they are 4.6, yes, they may as well be 4. They may as well be 3. But what's important is that every state equitably would, on the basis, on the doctrine of federal character, be fairly represented. And it will take care of the lopsidedness which currently exists, where you have some states of the Federation having as many as 4 judges in the Federal High Court, while some will have only 1. And some, for a while, might not even have any at all. Having an equitable number from different states, of course, has something to do with the cases, because hardly does any judge of the Federal High Court even serve in the state of origin. Once you are appointed a judge of the Federal High Court, you are moved, to any part of the country. But essentially, for us to be able to help the judiciary take care of the volume of cases on its docket, there's a need to increase the number. Let me also add, Mr. President, distinguished colleagues, that this bill, sponsored by His Excellency the Deputy President of the Senate, is actually a stakeholders bill, because it's an aggregate of the thinking of stakeholders within both the judiciary itself, that's the bench, as well as the bar, as well as members of public who also feel there is a need to have more judges to be able to do, the work. And as much as possible, this will go a long way in trying to make our lives easier as a nation and helping the dispensation of justice. Thank you, Mr. President.
Thank you. Distinguished Senator
James Ebio. Mr. President, I also want to add my voice. The bill sponsored by my brother, friend, and colleague, His Excellency, the Deputy Senate President. Mr. President, it's a consequence of what we have done. It's a consequence of what we have done. So it's a natural flow. And therefore, Mr. Deputy Senate President, I want to thank you for at least drawing attention to the fact that because we have done this, this is supposed to have been done. And the only way by which it can be done is by law. And that is the motive behind this particular bill. Mr. President, Senator, the Federal High Court came into being. Before that time, there was no Federal High Court. But because society is evolving and the number of cases that are coming up everywhere, they are rising rapidly as the population is also rising. And then the activities of human beings, the commercial activities and everything, together with even the election petitions. In fact, the one pre-election matters. As we speak now, a lot is happening in all the federal high courts across the land. Some of them are even directly affecting people who are seated here. And so,
are you referring to me?
Not at all. Not at all. You have no controversy. So, Mr. President, my respected colleagues, all that needed to be said have been said. But it's just the number. It's the number. You see, I will advise, particularly the judiciary, because this bill will be referred to the Committee on Judiciary. It's better we consult, because apart from the salary, there are so many other things that will follow as a consequence of this increment in number. Once the appointment is done according to law, that means so many other things will follow. We just listen to the incoming substantive Chief Justice of Nigeria. So whether or not the system will cope with that financial burden, to show that we will not appoint judges that will much later protest about what the system could not accommodate them. Because whatever the system is something that is done from here. And whatever we do here cannot go beyond what the portfolio is all about. And therefore, it is better we consult, particularly the head of the court. The head of the court. The Chief Judge of the Federal High Court. Oh, okay, but let him show so in open, so that in the final analysis, he will not deny what he has said in private. So, Mr. President, I also wholeheartedly support this bill. It's a good bill that will solve some of the problems we have in the society. Thank you, Mr. President.
Act Cap F12, Laws of the Federation of Nigeria, 2004, to increase the number of judges of the Federal High Court from 100 to 172, I repeal the Federal High Court Amendment Act 2013 and for related matters 2022, second reading taken. And the bill is referred to the Committee on Judiciary, Human Rights and Legal Matters to report back within 4 weeks. Leader of the Senate.